if you're going to speak, you have to hit the button until it turns blue. Okay? All right. I'd like to call the Town of Smithfield Board of Review, sitting as the Board of Appeals, to order. With us tonight, John Hunt, Frank Smith, Don Carrero is our what do we call him? Clerk. I'm Jim Buzzum. Our solicitor tonight is Mr. Anthony Galone. Vice Chairman Linda Marcello, Ed Savito, and Carol Ogden is the stenographer. Donna, could you read us the emergency and safety requirements?
In the case of an emergency, there are two main exits out of the chambers. The first is to the left side of the stage, up the stairs and down the stairway out to the back of the town hall. The second is out the back of the chambers to the stairway out to the front of the town hall. The men's facilities are through the back of the chambers, past the stairway around the corner on the right, and ladies' facilities are through the back door of the chamber, up the stairs and on the left. Please do not use the elevator in times of emergency.
Okay, before we read the formal case, I just want to announce to everyone in the chambers tonight, we are sitting as the Board of Appeals tonight, so there's going to be very little opportunity for discussion by the public, unless it's pertinent to the facts of the case. So this is not a normal zoning meeting. This is the Board of Appeals. Okay, with that, John, would you like to read the case?
Yes, case 24-012, GDM ESS LLC is applicant and owner of property located at 155 Mountaindale Road, listed as Plat 43, Lot 53, seeks to appeal the decision of the Town of Smithfield Zoning Department to deny the applicant's special use permit application to construct an energy storage facility and substation under section 4.3.D15 and 4.4.D15, utilities, public or private, in an R80 district.
Okay, thank you. Is the applicant here?
Yes, Mr. Chairman. We're ready. If I can start, Mr. Chairman?
Please.
Okay, Mr. Chairman, members of the board, good afternoon. John Mancini, I'm the attorney with an address at 56 Pine Street, and I represent the appellant this evening, or the applicant, noted as JDM ESS LLC, with respect to its application for the property as described as 155 Mountaindale Road, Assessor's Plat 43, Lot 53. And specifically, what the appellant is seeking and what is before you is a review of the decision that was issued by the zoning enforcement officer. Essentially, the zoning enforcement officer took the position in its correspondence and ultimately its decision that the applicant could not proceed with its proposal for a special use permit because its project was not vested. So I think, and what I'm going to argue here, is that the issue before the board is a very detailed, simplistic issue and really the question boils down to whether this application is afforded vesting rights. And I think that is really the crux of what you're going to hear and make a determination. But there's a lot that goes into that in understanding that, and a lot of it has to do with the fact that the law changed. We had some significant changes as of January 1st, 2024. So I want to just give you a quick recitation of the facts and what is before you as far as an application. In the fall of 2023, back in specifically October 19, 2023, the applicant submitted a pre-application meeting with the planning board. The purpose of the pre-application was to present to the planning board a land development project. And that land development project consisted of developing on this particular property, 155 Mountaindale, what is known as a battery storage facility. The applicant, in presenting its application, submitting the pre-application to the planning board, designated the property as R80, and also identified the use as being utilities, public or private, energy storage substations. And under your table of uses, that specific use is delineated. It's identified in each zoning district, and it is conditionally permitted, meaning that the use is not prohibited, but it is permitted subject to a special use permit. So in the R80 district, at the time that the applicant was before the planning board in October of 2023 for pre-application, the use for battery storage was permitted by special use permit. The laws at the time included what's known as Uniform Development Review. However, in October of 2023, Uniform Development Review was not mandatory. So it was not required that the planning board be designated as the entity which would be able to review variances, special use permits, and other elements that are normally reserved for the zoning board would now be delegated to the planning board. So in October of 2023, we were not before the planning board with respect to a Uniform Development Review. We were in front of the planning board for a land development project at a preliminary stage, very preliminary, noted as the pre-application stage. And at that stage is the time when the applicant solicits information from the planning board and presents their design. We had submitted all of that material, which is part of the record, and it was before the planning board. And at that point, we made clear, or we understood clearly, I should say, that the applicant was proceeding with the understanding that it would be required to obtain a special use permit from the zoning board as a land development project. And that process is multi-leveled. Land development project requires you to obtain a pre-application meeting, a master plan review, preliminary plan review, and a final plan review. In this instance, because we're requesting relief of the zoning board, we have to obtain master plan review, then zoning board review, then back to the planning board, then preliminary plan review, and then final plan. After we had completed our presentation with the planning board, we then submitted our master plan application. Master plan application was submitted in its entirety in November of 2023, specifically November 22nd, 2023. I'm a history buff, so that date is important to me because that was the date that John F. Kennedy was assassinated, so I can recall certain dates for certain instances. But nonetheless, on November 22nd, 2023 is the date which we submitted a full application for master plan. That master plan application included had the understanding, it included the information for also the special use permit. However, that application was not submitted to the zoning board. And the reason why the application wasn't submitted to the zoning board is that it could not be submitted to the zoning board at that point because we needed to proceed through the planning process. And that's very, and that is a very, very important point. I'm going to go back to it when we get to the actual letter from the building official. And the reason why that's important is because this project was not only governed by your subdivision regulations, which talk about the land development process, as I indicated, master, preliminary, final. It was also governed by Rhode Island General Laws 452361. And 452361 is a very important provision. It's actually the only, in this story or in this saga, is the only statute that was not changed in January of 2024. And, well, I shouldn't say that. In January of 2024, precedence of approval was modified, but was not, I'm sorry. In January of 2024, precedence of approval, Rhode Island General Laws 452361 was changed to incorporate the requirement of uniform development review. But at the time that we submitted our application in November of 2023, Rhode Island General Laws 452361 required that we have to obtain master plan approval, conditional master plan approval, prior to our ability to go forward to obtain a special use permit from the zoning board. So at the time that the application was submitted, the intent of the applicant and the requirement of Rhode Island General Laws was that we needed to obtain a review from the first level of approval, and that was master plan at master plan at the planning board. So my position in this instance is that the application as submitted to the planning department in November of 2023 is a comprehensive application which follows your checklist for master plan, meaning that if the checklist is not complete, you cannot proceed to the next level, which is a hearing before the planning board. That application incorporated the zoning board review and the requirement to obtain a special use permit, but the applicant could not file the formal application to the zoning board in November of 2023 because it needed to obtain conditional plan approval from the planning board. So the planning board had to grant the applicant conditional master plan approval for the applicant then to proceed to the zoning board to get a special use permit. That is the process that is described in your subdivision regulations, and it's the process that was mandated by Rhode Island general laws in 2023, November of 2023, under 452361. Once the application was submitted to the planning department then under your regulations and under the subdivision regulations has a certain time period in which it has to review that application to determine whether or not it's complete. The planning department did that, and the planning department in December 17, 2023, issued the applicant a certificate of completeness. The certificate of completeness is a very important document because that document indicates to the applicant, to the planning department, to the town of Smithfield, that the applicant has met the requirements of the checklist. At that point, once the applicant receives a certificate of completeness, it is then placed on the agenda for hearing before the planning board. So my position is in December of 2023, specifically December 17, 2023, the applicant is notified that it has a certificate of completeness. It is now qualified to go to the planning board to have its review. At that point, we are vested with respect to the ordinances and laws that are in place as of December of 2023. And that incorporates the special use permit, and it incorporates the table of uses. So the laws in place in December of 2023, which included your table of uses, which permitted in that table of uses that that utilities, public or private, energy storage or substations are permitted in the R80 zone by special use permit. Now, in January of, and so I want to read to you for the record.
Excuse me, Mr. Mancini.
I'm sorry.
That just reminded me of something. Please, everyone, if you have a cell phone, turn it off or put it on silent so that we don't have these interruptions again. Thank you.
Thank you, Mr. Chairman. So I just want to, for the record, and I don't want to prolong this, but I just want to be clear on it. So in January of 2023, in December of 2023, the precedence of approval required the applicant to obtain both, to obtain an approval first at master plan and then to go to the zoning board. In June of 2024, that statute precedence of approval was changed. 452361 was changed, where it stated that an applicant requires both a variance from the local zoning ordinance and a planning board approval. The applicant shall be reviewed under unified development.
It shall be.
Reviewed under unified development review pursuant to Rhode Island General Laws 452350 and 452446-4. So
46.
452446. And I apologize, I'll slow it down. Essentially,
What was that date again? I'm sorry, I didn't.
no, there wasn't a date, so, I'm sorry. So in June of 2024, Rhode Island General Laws changed, or the Rhode Island General Assembly changed the precedence of approval statute.
Like 90 days ago.
I'm sorry?
90 days ago.
Oh, I'm sorry, no. June 2025 was the effective date. So let's go back. So January of 2024, the statute changes. However, the statute has an effective date of June of 2024. So effective June 25th, 2024, Rhode Island General Laws relative to the precedence of approval, which is 452361, requires a review by Uniform Development Review, and it's a statute that I just read. So that changes the dynamics, because now it says that the zoning board on an application which normally would come to the zoning board doesn't go to the zoning board, it goes to the planning board. But the statute under which we were operating, 455361, in effect in December of 2023, was different. It did not mention Unified Development Review. It essentially allowed for us to proceed the normal way, planning board, zoning board. And the reason why that's important is because in December of 2023, when we received our certificate of completeness, we could not file an application to the zoning board for a special use permit because we didn't receive the approval that we were required to obtain by the planning board with regards to our master plan. We could not get to the zoning board unless we received our master plan approval. And that is where I think the rubber hits the road here, where there is a discrepancy between my argument and the argument of the building official. Building official takes the position, well, because you did not file a application in 2023 with the zoning department, you're not protected by the ordinances and statutes which vest projects. And my position is that my certificate of completeness, which was issued by the planning department relative to my land development project, which included a special use review, vested me under those ordinances. I didn't need, under Rhode Island general laws and under your ordinances, I did not need to file two applications to two separate bodies to be vested under the existing ordinances and laws that were in place in 2023, because I filed with the appropriate body who had exclusive jurisdiction at that point, which was the planning board, on this land development project that incorporated preliminary plan, master plan, final plan, and special use permit. And I met the obligations of the checklist as deemed acceptable by your town planner, evidenced by the certificate of completeness which was issued. That certificate of completeness goes beyond the requirement of the state statute. State statute simply says that you have to be substantially complete. Here, we were beyond substantially complete as we had the certificate of completeness. So, in sum, and no need to belabor it, but our argument, so I think that the issue before you is one of whether or not we were substantially complete under Rhode Island General Laws 45, 24, 42. And that's a determination this board has to make. This board has to determine whether or not the certificate, well, it has to determine whether or not we're vested. And so the first thing it has to look at is it has to determine whether or not the certificate of completeness, which was issued in December of 2023, applies to the zoning board's requirement for the issuance of the special use permit. And does the application for a master plan, which is governed under the precedence of approval under 45-2361, incorporate the zoning board? It may be a novel legal issue, but I think that it's a very simple one if you follow the sequence, if you follow the sequence. And the sequence is laid out in your land development project, in your requirements for land development project. Pre-application, you can check that off because we met the pre-application. We were before the board on pre-application. Master plan, we received a certificate of completeness for master plan. We did not get the hearing for master plan, but we were vested because of our certificate of completeness. Had we had the hearing for master plan, we would have been able to then proceed to obtain a special use permit if we received the conditional master plan approval. You don't get to second place without first, I should say, you don't get to second base without first touching on first. And that's the precedence of approval. But that process is all one. And that is where I think the building official fails here, because it fails to recognize that the submission of a land development project is submission of a complete project. It's not, you can't take one aspect of it and maintain it in a vacuum. And the error of the building official is to say that because you didn't submit prior to January of 2024 or prior to February of 2024, your application to the zoning board, you're now out. And why are you out? That's an important point and a very important date, one that we don't recognize because we don't believe it to be effective to us. And that's the February 6, 2024 date, because on that date, the town made a conscious determination to prohibit battery storage in all areas of the town. So going back to the original position where the battery storage proposed in this application under utilities public or private was permitted by way of a special use permit, in February of 2024, the town ordinance was changed so that now batteries are prohibited in all uses. We don't believe that is applicable to us because our project, our proposal as a land development project, received a certificate of completeness in December of 2023, predating the effectiveness of your ordinance prohibiting batteries. The building official takes the position that because we didn't submit prior to February of 2024 to the zoning board, that we're not able to proceed because it's a prohibited use. But that ignores the certificate of completeness and ignores the master plan. So does that mean that I can go forward on my master plan for review of master plan, receive a conditional master plan approval, but then I can't go beyond that because the use is prohibited? Or am I barred from even going forward on the preliminary plan, on the master plan, because the use is prohibited in February, but I have a certificate of completeness which was issued in December? So that begs the question, which is an important one as a precedent going forward, what does a certificate of completeness mean? To me, a certificate of completeness has always been an important document. It means that you've met the checklist requirements. You have satisfied the elements necessary to proceed. But if you're now saying that that certificate is no longer viable because you can't go forward because your use doesn't exist, then that document, that process is irrelevant. Then essentially, an applicant can come, present an application, have a certificate of completeness, and the town council the next day can change the ordinance and eliminate that project by making the use completely prohibited. That's not a process that is equitable, and it's not a precedent that this town wants to create because it's not one that's permitted under the state statute. The state statute talks specifically about vesting rights under 45-24-44, and simply says that if an application is substantially complete, that application is vested. And the reason for that is clear, because you want to preserve certain rights and you want to ensure that those that rely on your statutes and rely on your ordinances and make the presentations and expend the resources that are expended are protected. Your job is not only to protect the town, but it's also to protect the process. You sit as a quasi-judicial body and you have to weigh the evidence appropriately in conjunction with the statutes to ensure there's a justified process. Here, if you believe that certificate of completeness is an irrelevant document, I think that significantly jeopardizes the process. So in conclusion, I believe that we argue with substantial support from state statutes that the certificate of completeness is a document that has created vesting rights that permits this project to go forward under the laws in existence as of December of 2023. That means that the February ordinance, which changed or prohibited battery or changed the table of uses, is not applicable to this project. That the applicant is permitted to proceed to master plan review and then proceed with the land development project to the zoning board and then to preliminary plan. That process should not be closed to this applicant. And finally, the building official erred in not recognizing Rhode Island General Laws 452361. Makes no mention of it anywhere in its decision. Simply says you did not submit an application to the building department prior to February of 2024. You're therefore not permitted to go forward. So with that, I'll entertain any questions the board has.
So I guess one of the things that is apparent is your reliance on what is substantially complete.
Yeah, and
And
I don't even-
the fact that, so you have followed a process that has many steps in it, and you've got acceptance of approval for a step, but not all the steps all the way through. So
Yeah.
whether you consider that step to be substantially complete may not refer to the entire process to be
Yeah.
substantially complete.
Yeah, no, I think that's a good question. And it goes to show how multifaceted this is. And my position is that I don't have to show substantial completeness because I have a certificate of completeness. I've completed the first step, and that's all I need to do. I don't have to complete all the steps to be vested because that wouldn't make sense. And your ordinance doesn't require me to do that. Your ordinance doesn't say that in order to be vested, you have to have a master plan approval or you have to have a preliminary plan approval. The state statute doesn't say you have to have an approval. What we're saying is that we are vested because we have a certificate of completeness on a major land development project, which was issued at master plan, which is the initial stage. Without having gone through that stage, without having completed that stage, without having obtained some type of approval from master plan, we could not proceed to the zoning board. So there was no obligation of the applicant to make a petition, application, or request to the zoning board in December of 2023. Said another way, I mean, my certificate of completeness is my ticket. I punched my ticket to go to the process, you know. What the building official did is stop that process by saying, no, you needed another ticket. You needed a ticket from the zoning official. You needed an application to be filed not only with the planning department for master plan, but also with the zoning board for your special use permit. My argument is that second ticket isn't necessary because of precedence of approval, 452361, because that says I don't get to second base unless I complete first base. So I've got my first base ticket. I've got to finish that ride before I can get onto the next bus.
Okay, thank you.
Thank you.
John, would you like to submit any exhibits?
I think it's all, I'm going to rely on what we have submitted. I'm relying on what's been submitted to the planning board, which is our pre-application, what was submitted for master plan, what was submitted in my correspondence, which was part of this appeal. And then my reliance is on the Rhode Island General Laws. I think this is strictly a legal issue. This is an interpretation of the laws in place in 2023, and it's an interpretation of the new laws that came into effect in January of 2024, as well as June of 2024. And the court ultimately is going to have to interpret how those statutes into play.
Mr. Messina, I don't understand, why would something becomes effective in June of 2024 have relevance to this case when we're talking about December of 23 and January of 24?
Yeah, that's a good question. So the statutes become effective, the statutes get enacted in January 1st of 2024, but they have effective dates of June of 2024. And to be honest with you, the change to the precedence of approval, which is in June of 2024, really doesn't have any effect here. Doesn't really have any play into it. I make reference to it because I think it's important to know that between December of 2023 and January 1 of 2024, there was a lot in play because a lot of the laws changed. So we kind of got caught in the middle of that. But it is important because in the record, you'll see that there's a request that the application proceed at master plan under the Unified Development Review Statute because.
But which were not in play.
Well, no, it was not in
Okay.
play. It was not in play in 2023. And you're absolutely right, Mr. Chairman, and I think that's important to keep in your mind as you deliberate this. the new statutes in December of 2023 were not in play. So the requirement for uniform development review was not in play in 2023. I had no right to request uniform development review, which we didn't do. But what we did do is request a conditional master plan approval subject to a special use permit as part of the land development project, and we received a certificate of completeness for that.
We received.
A certificate of completeness for that.
Board, do you have any questions for Attorney Mancini?
I do, I have one. I heard you say intent was to do this, but we're talking about two different boards. We're at the planning board, but your intent was to come to the zoning board.
No, I had no, well, I shouldn't say intent. I think I should say my hope was to come to the zoning board after I received an approval from the master plan. I couldn't come to the zoning board prior to it. In other words, if in December of 2023, I filed an application to the zoning board for a special use permit, the board wouldn't accept it. You wouldn't hear me because I didn't have a plan. I didn't have a master plan approval. So you would tell me to go back to the planning board, get your master plan approval, and then come back to the zoning board, because that's the process. So, if I said I intended, yeah, the intent is to follow the process. The hope is to receive approval at each step so you can continue in that process. So my argument was that when we submitted master plan, we submitted a complete application which incorporated the special use permit requirement of the zoning board. That's that master plan.
So what do you mean when you say you incorporated that requirement, if you couldn't?
I didn't incorporate that requirement. That requirement was, that was a requirement of me whether I wanted to do it or not do it because of two things. One, of the land development ordinances that you have in place, and then the second is precedence of approval, 452361, which addresses what an applicant has to do when it's required to obtain both approval from the planning board, approval from the zoning board, or approval from the town council. Another example is if I needed to obtain a zone change, I wouldn't file for the zone change unless I had a master plan approval, because the town council is not going to give you a zone change unless they know what your plan is on a land development project. I'm sorry.
It's not going to give you a zone change
Unless you have a master plan approval that shows what your plan is, it's logical. And so for the building official to say, no, you needed to file with the zoning board in order to be vested, I think that is an error. I think my filing with the planning board, my receipt of the certificate of completeness incorporates the zoning board because it's all part of one process.
So it wasn't like you needed to complete all of your steps and then come to the zoning board.
Right, I needed to complete one step. I needed to complete the master plan. That's the first step. After that base hit, I go to the second step, right? The process is simple. You start at home plate, you go to the first plate, which is master plan, conditional master plan approval. You go to the zoning board, you get a special use permit, go back to the planning board for preliminary plan, then you go to final, and then you come home. That's the process. And you don't get to second base unless you start that process, you get that certificate of completeness. Without that document, I couldn't do anything. And now for the board, I take the position, well, the certificate of completeness irrelevant. You needed an application to be filed with the zoning board. You need a certificate of completeness with the zoning board. So what I'm being told by the town of Smithfield is that in order to be vested, in order for this project to continue now because the law has changed, is you need to show me two certificates. You need to show me a certificate of completeness from the zoning official showing that you filed your permit request with the zoning board, and a certificate of completeness with the planning board. You need two documents, you need two tickets. That's not what I believe the law to be.
Okay,
Okay,
thank you.
thank you.
Good evening, Mr. Chairman, members of the board. For the record, my name is Kelly Morris Salvatore. I've been engaged to represent Christopher Gentile on this matter as the zoning official. I want to clarify a few things because I think John just misspoke on timing. So in June of 2023-ish, or mid-2023, the General Assembly adopted a whole set of new, they call it housing legislation. Those pieces of legislation generally, and the ones we're talking about tonight, were effective on January 1st, 2024. So when Mr. Mancini suggests June, I just want to clarify the record and be clear that the unified development, everything that he's talking about, that took effect in January, not June. So when you, Mr. Chairman, says, why does that matter? It was January, not June. So I just want to clarify that. I also want to clarify, I have a whole set of a PowerPoint here for you, but I just want to respond right at the outset to some of Mr. Mancini's comments about procedure. In 2023, when he applied, the precedence of approvals that he's talking about required him to file with both the zoning official for the zoning relief and the planning official, planning director usually, for the planning relief, the site plan review, the master plan review. That didn't happen. I'm going to go through what exactly happened in a couple of minutes. What precedence of approval said in 2023 and was effective in 2023 is you go to the planning board for your first stage of approval, whatever that is, in this case, master plan, and at the same time, you get a recommendation to go to the zoning board. That's in 2023, when there were two different boards hearing these applications. On January 1st, that changed, whether the town wanted it to or not, as Mr. Mancini described. It became a unified development review. That did not take away the requirement that a zoning application had to be filed with the zoning official, not the zoning board, the zoning official. And I'm going to go through your ordinances to clarify that for you. So, as Mr. Mancini said, there's one thing we definitely agree on. This is a purely procedural issue. And simply put, Green Development did not file the zoning application that was required to be filed requesting the special use permit with the zoning official until after February 9th, when that new ordinance took effect and battery storage is no longer permitted in the town of Smithfield. So with that, I did give you a package which Mr. Mancini did not object to. The first set of documents is the PowerPoint so that you can read them better than what's on the screen. And, yes, I have
Go.
Yeah, we need one more. Yes.
And the second set of documents are exhibits that I'd like entered. So we'll be going through those in the record.
Do you want to treat those, you want to call them out as separate exhibits? Or
Yeah,
you
so
want- or you
they're
want one-
numbered, they're numbered. So once we go through them, you'll see.
Oh, yes, they are, okay. I see
okay.
that now, yep.
Try to make things clear and efficient for you.
And are we going to the PowerPoint now?
Yeah, but I mean, it's right in front of you also, but yeah, for the audience, if you want to dim the lights. So I'm just going to walk you through what actually occurred so that you understand what the process was. So a zoning certificate, which is the first slide, was issued on October 4th, which generally advises the applicant that the use is permitted by special use permit from the Zoning Board of Review. And at that time, I think it was called utility storage or something like that. And then on October 19th, the applicant appeared before the planning board for a pre-application. So that's before the master plan application gets filed, before the special use permit application gets filed. During that meeting, Mr. Mancini acknowledges that he needs a special use permit from the zoning board, and that unified development review is not required at this time. Again, it's before January 1st, so you go into both boards. A master plan gotta do these. So this is the pre-application. And at the time, because it was prior to January 1st, the town of Smithfield did not review development proposals under Unified Development Review, thus requiring the application to and review of both the planning board and the zoning board. So next, what happens is the master plan application is filed. This happened on November 22nd, 2023. Importantly, There was no special use permit application filed at this time. It was required to be filed, I would say, at this time in order to proceed to even the planning board, because the planning board has to make a recommendation to the zoning board. This master plan application was deemed complete towards the end of December. Then a zoning ordinance amendment is enacted by the town council in early January, and this amendment doesn't take effect until February 9th. So it adds the definition for battery energy storage facility, and it prohibits battery energy storage facility use in all zoning districts. And it's effective February 9th, 2024. That does not take away the requirement that you have to file a zoning application with the zoning official to ask for the special use permit. And they had until February 9th to do that, but they did not do that. So I think it's important to talk about a case that I found at this point. It's called Granite Asphalt Corp. Versus Zoning Board of Review of the Town of Johnston. And the facts are very similar in that case. So in the Granite matter, the property owner proposed an asphalt plant on their property. They relied on the representation of the building official that planning board review was not required. The property owner even prepared a site plan that he intended to submit to the planning board, gave it to the building official, who generally is also the zoning official, and the building official said, no, you don't need planning board review. So he issued the building permit. In reliance on that permit, the property owner actually started constructing. The building official gets replaced shortly after that, and now the new building official is getting complaints about the construction, about the use. So the new building official investigates and issues a cease and desist order saying, this use is not allowed. I'm sorry, not the use isn't allowed, that this use required site plan review. So there were two appeals. The first appeal, the Supreme Court of Rhode Island said, no, you needed site plan review. So this whole substantially complete and how many people do you have to apply to? You still have to apply to the appropriate official. They didn't do that. So that stuck. Fast forward a few years, when they finally make it through this appeal, now the asphalt plant is not allowed. So they apply to the planning board and they say, oh no, we want to rely on the 1994 provisions because we applied for a building permit, similar to green development applying for the master plan. The court said no, because you didn't apply to the proper official, i.e. the planning director, for site plan review, you're out of luck. The use is prohibited and you don't get to look back to 1994. The court said in determining the appropriate review agency during the application process, the applicant must refer to the relevant zoning ordinance. In that case, it was clear in the Johnston ordinance that they had to apply for site plan review and they had to apply to the planning board. I think the next, so here's the special use. Oh, so the green development actually did apply for a special use permit, but they submitted it on April 10th, 2024. And that's kind of how this appeal comes to you, because Mr. Gentile said, I can't accept this because the use isn't allowed on April 10th, 2024, and since February 9th. So that's the genesis of this appeal. Now, pre-January 1st, 2024, the creation of vested rights says that a zoning ordinance provides for protection for the consideration of applications for developments that are substantially complete and that have been submitted for approval to the appropriate review agency in the city or town prior to enactment of a new zoning ordinance or amendment. And, excuse me, in Smithfield, your vested rights section is at 11.3, which I've added to the PowerPoint. It says the same thing. With regard to applications for a special use permit, it's the official who is designated to receive such applications. If you look at the bottom of that page, the zoning official is the official. So when they say the official, they mean the zoning official. So for variances, special use permits, you must apply to the official. So this isn't about, applying to the zoning board because it's now Unified Development Review. And today, you still need to fill out that application for special use permits and dimensional variances. You still have to apply to the zoning official. There's two separate applications. The planning board application for master plan doesn't include the requirements that the zoning application includes, which generally are they ask the applicant, what's your reasons for this variance or special use permit? And you include a brief paragraph about why you believe that you are required, that you're entitled to a special use permit. So those are two separate applications, and the fact that they did not apply before February 9th is the reason that the building official, zoning official, denied the, or rejected the application. So again, this is really about when the application was filed. It was not, there was no application to the zoning board before January 1, and I would even say before February 9th to the zoning official. There was no updated Unified Development Review application, so towns can draft a new application for Unified Development Review. You don't have one. You have two separate applications still for zoning relief. So even applications going forward, if it's going to be reviewed by the planning board, they're still going to have to fill out two different applications. Battery storage use became prohibited on February 9th. No substantially complete application was filed. And unfortunately, Green did not have its rights vested in that prior ordinance. And with that, I'd ask you if you have any questions.
Thank you. That was nice and succinct and pretty straightforward. Board members, do we have any questions for Ms. Moore-Salvatore? Okay.
As far as exhibits, Ms. Morris?
So I've asked that all of those exhibits be accepted by the board. Mr. Mancini does not object. The exhibits are all of what I just went through with the PowerPoint. So there's a zoning certificate, there's a pre-application.
Well, this whole packet is labeled
Exhibit.
as Exhibit 1.
Yes, well, no, if you go through it, there's,
There's other ones.
Oh, yeah.
There's
yes,
other
yeah,
ones.
Oh, yeah. Okay.
we just stapled the whole thing together just to keep it together.
Do you have a copy?
Yep, John has a copy. Yes, please. So, Mr. Chairman,
Yes.
again, it's really just about the fact that they didn't file the zoning application. It's really as simple as that. The request has to be made, it has to be made separately, even under UDR. You have two separate applications. One is for the master plan, and one is for the zoning. The zoning never got filed and was never accepted as complete before February 9th.
Okay, thank you.
Thank you.
Do you have anything else, John?
I just want to, just a short reply. So I think although we disagree on some issues, I think the most important disagreement here is with regards to the precedence of approval. And the town zoning official taking the position that two applications needed to be filed, an application to the planning board and an application to the zoning board. 452361 speaks to that, and the ordinance, I'm sorry, the statute in effect at that time reads as follows, and I'll go slow for you. Where an applicant requires both a special use permit under the local zoning ordinance and a planning board approval, which is what we have here. So we have a requirement for a special use permit and a planning board approval. that an application is not undergoing unified development review pursuant to section 452350.1 and the local zoning ordinance, the applicant shall first obtain an advisory recommendation from the planning board, as well as a conditional planning board approval for the first approval stage of the proposed project. So the statute says that at the planning board, I'm doing two things. I'm getting an advisory recommendation that goes to the zoning board, and I'm getting a conditional master plan approval. And it says, which may be simultaneously. So I can do it at the same time. I don't have to. It says may be done simultaneously. Then the important word in that statute is, then obtain a conditional special use permit from the zoning board, and then return to the planning board for a subsequent required approval. So this statute, which is the governing statute, does not say that the applicant is required to make an application at both the planning board and the zoning board. Your ordinances do not say that the applicant is required to make a application submission to the planning board and to the zoning board. You make it first to the planning board, you go and you obtain your approval at the planning board, and then you go to the zoning board. So if you follow the logic that's being described here, then essentially the certificate of completeness and the planning board approval process, I can go through it, but it means nothing because the use doesn't exist. There's no vesting, there's nothing that took place. And when we talk about substantial completion, and you talk about 452444, which says that a zoning ordinance provides protection for the consideration of applications for development that are substantially complete and have been submitted for approval to the appropriate review agency. That substantially complete doesn't mean that your development is substantially complete. It does not mean that your approval is substantially complete. It means that your application is substantially complete. And here, what we've done is we've gone beyond that. We have a completed application. We have a certificate of completeness. The purpose of that law,
For a specific stage,
for the beginning stage, for master plan.
substantially complete for initial stage, not for the full application.
Well, without that stage, I couldn't go to the next stage.
I'm
So
not.
I couldn't file.
Sure, it's always sequential, but.
Well, if the logic is, in order to be substantially complete, when you file your application, you need to file 3 applications. Actually, in this instance, you'd need to file 4. You need to file an application to the planning board for master plan, an application for preliminary plan, an application for final plan, and then you have to submit an application for the zoning board. And only at that point can you be considered vested. That doesn't make sense. But if that's the process, then that's the process. But that doesn't make sense. And that certainly doesn't comply with 452444. And then my sister makes a lot of focus or speaks to the language which says, submit approval to the appropriate review agency. Well, the appropriate review agency was the planning board. That's where we submitted our application. And again, we couldn't go to the zoning board unless we received our consideration and approval for the planning board. So that's essentially the argument. As I said, it's a legal argument with much interpretation. With respect to the effective dates of January or June, there's a bit of a discrepancy because some of these statutes, all the statutes came into effect in January of 2024, but the legislature gave municipalities an additional 6 months to do a catch-up. So because then all municipalities were caught up with respect to revising their statutes or their ordinances to be in compliance with the statute. But whether it's January of 2024 or it's June of 2024, I think it's irrelevant in our argument because the question that's overarching that you have to determine is what were our rights in December of 2023? Where are we vested relative to both the planning board and the zoning board? Thank you, Mr. Chairman.
Thank you.
Just quickly, I think Mr. Mancini is kind of summarizing what he believes the ordinance might be interpreted as. But just to go back to 442444, which is creation of vested rights, and this is what the Granite Supreme Court case said. This is exactly what they were relying on. A zoning ordinance provides protection for the consideration of applications for development that are substantially complete and have been submitted for approval to the appropriate review agency in the city or town prior to enactment. Now, in that Johnston case, they reviewed the Johnston zoning ordinance and found that the planning board was the agency that had to accept these applications. Your section 11.3 in your ordinance says that, and so for completeness of application, which is the vesting, any application for development under this ordinance or a previous ordinance, including an application for a special use permit, shall be deemed substantially complete when all required documents, including plans, together with required fees, are received by the official designated herein to receive such applications. Then under 10.8, for variances and special use permits, this is the same language that's in here today as it was in 2023. An application for relief for a special use permit, I'm leaving out unrelated information, may be made by any person, provided that the owner or owners of the subject property must join in any application by filing with the official an application describing the request. And then the definition of the zoning official is hereinafter referred to as the official. It is the zoning official that accepts these applications. In 2023, when the master plan was filed, there was no request for a special use permit. So even if they went to the planning board, what would the planning board be recommending on under the precedence of approvals? There was no application pending. So it's just important that they had to ask for the special use permit, and they did not do that before February 9th.
All right, thank you both. Appreciate your very learned presentations. Now I'd like to open it up for public comment. Just remember that we're not talking about a particular project or use at this time. We're talking about the process and the selection. So if anyone from the public would like to offer comment regarding this application. Please state your name, please.
Good evening, Mr. Chair, members of the board. David Ursillo, 119 Mountaindale Road. I'm about 350 to 400 feet from this project.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please proceed.
Just want to dovetail on a few of the arguments that have made. I'd like to start with Member Hunt's comment, where he piggybacked off Attorney Mancini's, his intent when he submitted his application in November to the planning board. The intent, what he really wanted to say when Mr. Hunt popped into that was, his intent was he wanted to get the special use permit application, but he didn't. What he's trying to inform this board is that his intent was it was supposed to be part of the application. It wasn't. As counsel for the building official has stated, they didn't submit it at that time. You cannot infer intent from the planning board master plan application. When that application was submitted and certified complete, all that does is certify that the documents the planning department needs to present this application to the planning board triggers the time frame for the application to be heard. It does not do anything with respect to vesting rights. Attorney Mancini's argument is trying to say that's what his intent was to inform the planning board he was going to need a special use permit, but there's nothing that states that. The application was not submitted at that time. The second point I would like to dovetail off of is counsel for the building official regarding the Johnston case and the arguments regarding vested rights, because I interpret the vested rights, that there was nothing invested at that time. First, nothing was vested because the actual zoning certificate submitted does not vest anything, first of all. That's just guidance for the owner of the property to understand what may be allowed on that property. Case law specifically says that a certificate for zoning does not mandate or does not provide any law or justification that you can or cannot do something. Now, that actual certificate, how it's been presented in some of these documents is interesting, because I keep hearing that under that zoning certificate, there was a battery energy storage system allowed. There isn't anything in our zoning ordinance, when that zoning certificate was submitted, that specifically said there was a battery energy or an energy storage system available. The way I have read the zoning use table, one moment. It's in 4.4, where it begins to define what I believe, because I couldn't really see the zoning certificate digits. I need to scroll through my notes here. The zoning certificate states utilities, public or private, utility facility, energy storage, and substation. That's what was applied for. But yet, that mention of utility, first of all, doesn't necessarily mean they were a utility in the first instance. But the other part of it, which says energy storage, they went under D15, is that correct? So under D15, the way I read the use table, utilities, public or private. Public or private utilities, such as a transformer station, substation, pumping station, public water tower, tank, automatic telephone exchange.
Public water tower.
Tank
Tank.
or automatic telephone exchange. There wasn't anything, I believe, that said there was an energy storage allowed in that specific 4.4 D15. So the whole process became flawed. For them to then say we're vested because we got the zoning certificate and then we went to get a master plan application, there's a flawed process to begin with. And additionally, not only is it flawed, under all this argument regarding vesting, the cases cited by Attorney Morris, there's other cases also that I've found, that I've interpreted that vesting is not as vested as everyone thinks. And there is case law in the Supreme Court, besides the case cited, that supports the fact that projects at a much further step in the stages than this project, preliminary plan, final plan approvals, building permits being applied for, which was the case she cited for. This case isn't anywhere near that. And in those cases, our courts have held amendments to the zoning ordinance can negate what was originally approved or granted. And there's a case, Del Bonis versus Town of Richmond. The court says, we have held that a municipality amends a zoning ordinance in a manner such that a once permitted use becomes illegal. The amendment can result in a revocation of permits that were issued under the previous ordinance. The record in this case doesn't even get this applicant to the permit stage. They're not vested with anything. You take the town's arguments, which are definitely supportive of the denial of this appeal, and you can add there isn't anything vested. This appeal should be denied. Thank you.
Thank you. Good evening, sir.
Good evening, Mr. Chairman.
Please state your name and address for the record.
Attorney Joseph Wazalewski on behalf of Elisa Wazalewski, 115 Mountaindale Road.
Do I swear an attorney? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you.
I just wanted to make one simple point. As I agree with everything Mr. Ursillo said and Attorney Morris said, but I just wanted to make a simple clarification. Mr. Mancini stood in front of this board and represented that he cannot proceed to file a special use permit until after master plan is approved. Yet that's exactly what he did. Master plan was never approved here, and he filed the special use permit application after the zoning amendment of February 9th. So to stay in here and say, I could never file a special use permit until I'm approved for master plan is false, and is as indicated by his actions. He filed the special use permit application without receiving master plan approval. I just want to make that simple point because I think it was a whole. And I also agree that this appeal should be denied. Thank you.
Thank you. Any other comments from the public? Okay, not hearing any. I'd like to, attorneys, are you good? Okay. I'd like to,
Yeah, I want to respond to that final point, because that's a good point. We did file, after we filed the preliminary plan, we did file the special use permit. We did that so we could start this process. We needed a determination from the building official that he was going to deny us. It wasn't going to deny us. It wasn't going to allow us to go forward unless we filed an application, and then we got a denial. It was the only way to start the ball rolling, because otherwise we wouldn't get an appeal. So, and then we were told at that point by the town, you need to file a special use permit. So that's the reason we did it. So that wasn't in any way, shape, or form as a acquiescence to the process or a subsequent remedial measure. It was to subsequent remedial measure. It was an ability to get to a determination as to whether we were vested or right. So that's our issue.
okay, thank you. All right.
I'm sorry. But I have to respond to that because, you know, I've been advising the zoning official, and when that master plan was pending, I believe that the planning board would have had to deny it because there was no application for a special use permit. Therefore, there was no, you know, when the planning board grants master plan, they're assuming that a special use permit review is going to happen next because they've got the application and they're being asked to review that application, provide a recommendation to the zoning board, but nothing was ever submitted. So I think in terms of the required findings that the planning board has to make, they wouldn't have been able to find that it meets zoning because there was nothing to review. So I just want to be clear about, you know, if they had gone, they could have gone forward, but they would have gotten denied. So that's, I just wanted to clarify.
Quick question before she steps down. What the other attorney had written here about the general law 4523 50.1, that we have to provide a unified development review, but I believe you stated that that did not come into effect in Smithfield until 124.
Correct. So, but they still, so, you know, I do this in a lot of different towns. John does this in a lot of different towns. You still have to fill out two separate applications, even though it's unified development review. Some communities might decide to create an application just for unified, but I don't know of any that has. Everyone has to fill out both. And you have to provide it to the official that's designated by your zoning ordinance. In this case, it's your zoning official.
Okay.
I'm sorry, but just so we're clear. So I disagree with that. I mean, look, the process is clear. When you're at the planning board, under 452361, all you're doing is getting conditional master plan approval. And that conditional master plan approval is subject to your special use permit. If you never file for your special use permit, or you never obtain your special use permit, you lose your master plan, conditional master plan approval. And so it's not that the planning board is assuming, planning board's not assuming anything. The planning board is simply doing two things. It's reviewing your master plan. It's going to give you a conditional master plan approval subject to the receipt of the special use permit. And they can give you a positive recommendation or a negative recommendation. But there are no two pending applications. If you never file for the special use permit, you've wasted your master plan. You just don't have master plan. It's similar to a planning board issuing a preliminary plan approval subject to a DM approval. If you never get your DM approval, your preliminary plan means nothing. These are conditions of approval. The statute says it itself. You have to first obtain a conditional approval, subject to your special use permit from the zoning board. So it's, here, I think what we're doing is we're, I don't know, intermixing all these processes to get to an end. The end being, hey, we don't want this to be vested, but don't sacrifice the process for an unjustified end. That's just not right.
Okay. With that, I'll close the public hearing. Any further discussions or questions from the board? If not,
Can we discuss? or
Yes.
are we voting?
No, you can
So we'll
discuss.
we discuss first. Yeah.
So, I mean, he made my point, right? We've had many people come to us, they've had a preliminary plan, they've asked for special use before they go back and do all their other planning. That didn't happen. Right? So I think he made the point that they missed the, might have got the first piece, but there's no second
I'm sorry,
piece.
a little bit louder, Mr. Hunt, please.
I think
They
he made,
missed-
he made the point that, he missed the opportunity to file for the special use. We've had many people come, file for special use, and go forward with their plans. In this case, it didn't happen.
Any further comments, or if not, I'll entertain a motion.
I'd like to make a motion, Mr. Chair, make a motion to deny the appeal of GDM ESS LLC based on the evidence presented by Attorney Morris Salvatore that the applicant never acquired any vested rights with respect to its application for a special use permit prior to the effective date of the Town of Smithfield zoning ordinance amendment prohibiting energy storage and substation facilities in all zones on February 9th, 2024. Further move that the town solicitor draft a written decision incorporating the written, oral, and documentary evidence presented by Attorney Morris Salvatore supporting the denial of Green Energy's appeal of the zoning official's decision dated April 18th, 2024, which shall be forwarded to the zoning board for approval at its November 2024 meeting.
Okay?
Second.
Motion's been made and seconded. Any further discussion? Okay, so Richard, you missed the early part of the meeting, so we'll have Frank vote. So Mr. Smith will be voting as the first alternate. Okay, motion been made and seconded. All in favor?
In favor of denying.
Yes.
Aye.
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 Okay. With that, I entertain a motion to close the, adjourn the zoning board of appeals.
Chairman, I make a motion to close the zoning board of appeals.
Motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.